Good afternoon. Thanks for coming in today.
Thank you. Thank you for providing me with the opportunity to present testimony on this important legislation, and it's good to see all of you. I share Representative Lund's goal for making Michigan relevant in our presidential elections. I appreciate the opportunity to have this conversation and the concern about our role in the presidential political process. And I also think it's important to note that the Electoral College process, as it currently is flawed. Reform is needed. We have decreasing turnout in our elections. We have concerns among voters over whether every vote that they cast counts, that we have to be sensitive to and receptive to. And overall, to have a solid democracy, we need an informed and engaged electorate. And to the extent that our current Electoral College scheme is not promoting the ability for our voters to get information and to be engaged by the fact that some states are given more attention than others, that's a concern that we all should embrace and address. And that's why I appreciate this conversation. I appreciate a collective recognition of that problem. So reform is needed, but not this reform. And in fact, I do believe there are solutions that are better than this, and I appreciate the invitation perhaps to talk about some of those. Before I want to talk about a solution that does exist, that has been talked about nationally, and why that would be better, I first want to talk about why this reform is not the right reform for achieving our goals of increasing Michigan's relevancy in the presidential election process. I distributed to you a study from an organization called Fair Vote, which is a 501c3 organization that is really one of the only national organizations that does a lot of data collection and research in this area, and the question of both redistricting and electoral college reforms. So a lot of the questions that have already come up today, they have developed studies on, and I would encourage you to gather more of that data and information, and just from an informational standpoint, to have more data on the table as you sort through this process. Fair Vote calls this and other types of reforms, like the congressional district reform, a wrong way reform. And I just want to talk about a couple of the reasons why I agree with that assessment. Number one, I actually believe this would diminish our prowess in the Electoral College arena and increase our position as a flyover state because on its face it reduces the overall number of electoral votes that is given to the individual who wins the majority of votes in the state. And recognizing that Michigan currently gives 16 electoral votes to the winner of the majority vote in the state, we are already at a disadvantage, as has been talked about, with neighboring Ohio, which has 18, Pennsylvania that has 20, both of whom I think, similar to Michigan, have been seen overall as purple states. My concern is, on its face, this scheme automatically reduces by almost half the number of electoral votes that a candidate who wins the popular vote in the state can count on getting. And while we can make guesses about how a candidate will respond in a particular election to that reality, I think the fact that there is no data and no evidence that's been presented to suggest that a candidate will then increase attention to the state as opposed to increasing their attention to Ohio or Pennsylvania, where you could get 20 or 16 or 18 if you win all the votes. I think there's significant anecdotal evidence to suggest that this will not increase our presence in the presidential debate and increase the attention presidential candidates give to our state. And in the absence of data otherwise, I'm not ready to accept that it will increase attention and increase our relevance. But that's not the only reason I'm concerned about this reform. Another reason I'm concerned about it is, this is brought up, I have deep concerns about the Equal Protection Clause and the implications of the Equal Protection Clause with a scheme like this, where there's a lot of fuzzy math. It's not exactly clear how one vote is going to be allocated overall, and so that not only raises some potential equal protection concerns, which is of course the protection of one person, one vote, and that every vote is weighted equally, but on top of that, I'm deeply concerned about how voters will react to a change like this, that a legislature is enacting at the time in which it's being enacted, whether it's well-intentioned or not. Voters are already concerned that their votes don't count. They're already questioning the relevance and the efficacy of the Electoral College allocation. And if we add this confusing description as to how their votes will be allocated in a presidential election. I believe it's not only going to just be confusing to voters, but it will decrease their turnout and decrease their engagement and decrease their faith in the system. So with that, I guess I'll mention one more concern and then I'll talk about a solution. The other concern I have is just the ability for our voters to get information, which is really why we want Michigan to have the attention of both and all presidential candidates in a general election. I think anyone who in a presidential election has turned on the television in the weeks prior to an election day will recognize that Michigan still does get a lot of attention and money spent here by presidential candidates seeking to influence the vote. And that aside, where you have any type of structural reform to a process like this, you have to assume that our current two-party system, where we often have one candidate representing each of two parties, is not the way it's going to be in every election. The candidacy of Ross Perot has already been brought up, and I'm deeply concerned that if we are in a presidential cycle where there is more than two significant candidates, there is an independent party candidate, this current plan provides no opportunities for that candidate to have any type of recognition in the electoral process. All of that just speaks to, I think, the need to have more conversation, but again, question the way that this particular reform, even with the amendments that have been suggested, can actually achieve our collective goal of having Michigan play a broader role in the presidential elections, and also ensuring that our voters feel every vote that they cast will count equally and that they stay engaged. So on that, I want to bring the committee's attention to another proposal which has already been talked about a little bit, which is the National Popular Vote Plan. Several other states have looked at this. There's a lot of information out there, and that has gained bipartisan support on a plan that would essentially have each state allocate the majority or all of its electoral college votes to the winner of the national popular vote. This has been, in my view, one of the best proposals that, given the current constitutional restraints on the electoral college, can bring us closer to a one-person, one-vote ideal. So I would encourage the I would encourage the committee to look more into, if we do want to explore reforms, into that type of reform, which to me is all the reforms I've surveyed. I'm happy to talk about the congressional district allocation piece as well. Of all the reforms I've surveyed, this gets us closest to this ideal of one person, one vote being protected and every state mattering in the presidential election. Lastly, I just want to address a question Representative Heisey had about the Colorado reform. That was actually a congressional-based plan, congressional district. So it was a proposal on the ballot a few elections ago in which voters were given the opportunity to choose the ability to apportion their electoral votes by congressional district. That did fail. And so we have seen, at least in that scenario, where voters are given an opportunity that they rejected, even in a purple state like Colorado. So in conclusion, I just want to emphasize that I feel like we are in some ways having this debate at a time that could yield some confusion among voters and some concerns apart from the actual policy itself, which I believe is interesting, is not yet ripe, is not the best reform that's needed to increase our presence and relevance in the electoral college arena and the presidential election process. And I would urge the committee to not support this proposal on those grounds. I'm happy to answer questions.
Excellent, thank you very much. And I'm glad to have you hear you refer to this legislation as a proposal, because I was beginning to take exception to your reference of it as a scheme. So thank you for changing that verbiage. So my first question I want to ask you is along the same lines of what I asked Representative Lund, and that is, do you believe that Michigan, along with 47 other states, you mentioned the Equal Protection Clause, violates equal protection when a citizen goes to the ballot and casts his or her vote for the first place candidate, having that vote fully recognized by the winner-take-all system, yet a candidate or a citizen who goes in and votes for a second or third place finisher in a presidential election essentially has their vote count for zero because of the winner-take-all? How do you reconcile the concern for equal protection among the current system versus the proposed reform?
It's a great question, and as I said, from a policy standpoint, I don't think the current system is perfect. However, from a legal standpoint, the courts have generally upheld, because of the various other aspects of the U.S. Constitution, the courts have upheld our current winner-take-all system as being constitutional.
Thank you. Do you see a reason why the courts would not uphold a proportional allocation of our electoral votes? Is there a reason that you think a court would not, given, again, the constitutional provision that the legislature established the allocation of electoral votes?
I would certainly think that there is a viable challenge to this proposal under the Equal Protection Clause that would call into question two things. One, just the actual calculation of how votes are allocated and the untested aspect of that calculation. And then secondly, the overall confusing nature that does not translate directly from one person, one vote to an electoral college vote on the statewide level, as opposed to one person, one vote partially to a statewide winner-take-all and then partially in this percentage. I think I would be open to, and I think it opens itself to a Equal Protection Clause challenge.
But the current system has not opened itself.
Well, the current system has been upheld.
Right. So that was open to a challenge as well at some point.
The current system has been upheld as constitutional under both the 14th Amendment and other aspects of the Constitution.
After being challenged.
I would have to get back to you on the specific case
Sure.
that and the various different case law, but I'm happy to get you the citation.
Thank you very much.
Yes.
Appreciate that. Representative Yonker.
Thank you, Madam Chair. This is a very interesting discussion. So first I want to make a comment. We've had some questions brought up on the third-party candidates. How do we include them in this? Right now, they're not included. Third-party candidates get nothing. So you go with the top two. And I think you brought up a really important issue. And that is the fact that people are not engaged in voting because they don't believe their vote counts. And as a state representative, I get more accusations thrown at me from behavior on the federal level because people don't know what we do. They think we're all the same, and it's always the federal. And now we're taking a percentage of our population that votes, that realizes their vote doesn't count in the general electorate system. So you say the courts they upheld the current system, probably because they haven't had the opportunity to look at another one. Doesn't this and won't this encourage people to want to be voting, even though they may not be on the winning side, but at least they see their vote count?
I think, one, I would say under the current proposal, as I read it, the third-party the voters supporting a third party would not have their votes counted, whereas with the current, and I'm not here to necessarily, as I feel like I've stated, defend the current system. I do believe reform is needed, but under the current system, there is a third party. If a third party candidate wins the majority of votes in the state, then that third party candidate gets all the electoral votes. But I think the National Popular Vote Plan, which again would allocate our state's electoral votes towards the winner of the National Popular Vote, gets us closer towards the equal protection ideal of one person, one vote than the current proposal.
Thank you. Representative Heisey.
Okay, so I think we've all come to the conclusion that this bill in its present form is at best vague with respect to the rights of third-party candidates, independent candidates. I mean, we talked about a Ross Perot. We might have a Bloomberg at some point in the future, or Donald Trump. So, I mean, I don't know how they fit into this. My other concern is, obviously I agree with you that this could be open to challenge under an equal protection argument. When, in your opinion, would a challenge of that nature occur? Because if this bill were to be put into law, does that create a case in controversy for someone to file suit, or do we have to wait, God forbid, until the fall of 2016 when one or the other two top vote getters files an action presumably in federal court challenging the constitutionality of this, which could end up, now we're at another Bush v. Gore scenario when the electoral votes of Michigan are held up until 2017. So what's your thought on that?
I agree with your concern and your caution, and I would say either of those scenarios could happen. You could have a constitutional challenge immediately to this law upon its passage, or you could have an as-applied challenge after it's been in effect and after there's been an election. I would anticipate, although this is just as an individual, I would anticipate that based on history and the way we've seen reforms go forward at the national and state levels in other states, that you could see a legal challenge sooner rather than later. Either way, it only confuses the process even more. And so I think at most, before moving forward on any proposal, that the Equal Protection Clause question needs to be fully vetted, and that there has to be a full understanding of the legal complications and consequences that could follow the passage of any reform.
Thank you. Representative Shore. Representative Outman.
Thank you, Madam Chair. Maybe I misunderstand this legislation because, again, we talk about third-party candidates not having a voice in this process. So I might understand it, or misunderstand it, but I thought the legislation said the top two candidates who garner the most votes split it up proportionally, regardless of party, not just Republican or Democrat. Am I wrong in that?
That's correct. That's what the legislation says.
So it would eliminate the opportunity of a third or an independent third in addition to the two.
Much like our current system.
Yeah. So really, not a lot different than what we have.
I disagree, but
Okay. Thank you. Any further questions? Thank you very much for coming in today. Appreciate it.